72nd District Court mock trial. Judge Elwood Brown presiding judge. Be seated, please. I want to begin by taking this opportunity to welcome you to this mock trial tournament. This is the fourth year that we've been doing this, and the St. Clair County Bar Association and local lawyers have volunteered their time to not only coach you as teams, but also sit here as judges and participate in this event. Sheriff Donnellan is here as our bailiff, and it's unusual to have the sheriff as a bailiff, and normally we have bailiffs or deputies, but today we have the sheriff. And he and his department, other members of his department, are also volunteering their time in this courtroom and others for this tournament, and we certainly appreciate that. I'm going to, at this point, have the lawyers and the sheriff address you at the beginning. And I'm going to start with Sheriff Donnellan, if he'd like to make a statement here.
Well, good morning. This is our fourth year here in St. Clair County doing it. The Sheriff's Office provides all of the security for the bailiff. We very much enjoy this. It's wonderful to see the best of the best kids up and coming in St. Clair County. All the courtrooms you'll see are various deputy sheriffs of different divisions of my department. We're all in here on our days off on our Saturday because we truly enjoy this. So good luck this morning.
All right, and to make a few comments to you, we'll start with Mona Armstrong.
Good morning. My name is Mona Armstrong. I'm a senior assistant prosecutor here in St. Clair County, and I've been a lawyer for about 15 years, and I've spent the bulk of that being a trial attorney in our prosecutor's office. So I know very well what you're all doing today and how hard you worked to get to this point and how hard you're going to be working here this morning. I'm very excited to see what you're going to do.
Attorney Greg Strommers.
Good morning, everyone. Welcome. I know how hard you worked to get here. I look forward to seeing your presentations, and good luck.
And Cynthia Lane.
Thank you. I'm Cynthia Lane. I'm a lawyer in the private practice of law, and I've been a trial lawyer for nearly 29 years. I'm in my 29th year right now. I've participated in this program for 4 years. My first 2, I was a coach, and for the last 2 years, I've been a judge. So welcome and good luck, and keep up the good work.
Mark Davidson.
My name is Mark Davidson. I'm an attorney. Been practicing here in 30 plus years. I've been a judge, and it's been my pleasure to be a judge in this competition all 4 years, including this year, and looking forward to it. I'm a litigator. I do quite a bit of trial work myself. I also spent a couple of years in the prosecutor's office in my younger days too. So it's really fun to watch you. You had your first round behind you, so your jitters are all gone now, right? Good luck.
David Keys.
My name is David Keys. I'm a civil litigator, works in a local law firm. I've been practicing for 19 years. Good luck to all of you.
And as Sheriff Donnellan indicated when we came in here, my name is Judge Elwood Brown. I am a sitting judge in this county. I'm a probate court judge, but I sit as a family court judge and handle the cases involving abuse and neglect of children, juvenile delinquency, and divorce. I have been a lawyer now. I'm in my 30th year. I'm in my 10th year as a judge. Prior to being the judge, I was the prosecuting attorney in St. Clair County. Before that, I was an assistant prosecuting attorney in St. Clair County. I've spent almost my entire career in the courtroom. So what you are doing today is something that I have enjoyed for many years. And I'm pleased to see that you are here, willing to participate, willing to work hard, as you have to get you to this point, and are willing to step forward in front of strangers and show us what you got. So at the end, we will be giving you some critiques. Hopefully it's for the purpose of helping you in the future, identifying some of the things where you may have done better, or some things where you were very strong in what you've presented. So I hope you take it in that light. that there's no criticism here. Lawyers, and these lawyers, judges here did not mention this, as one of or two of them did last time, but there's not a case that went by that I ever tried that I didn't walk into the courtroom and be nervous about. And those nerves went away the minute you started into the trial. But when you walk through that door and you're all prepared to go, you better be nervous or you're not doing your job. So don't feel that those nerves are going to impair you at all. Work through them and you'll do fine. So at this time, in the case of of Young versus Gardner, are the parties ready to proceed? All right, would the plaintiff place their appearances on the record, please?
My name is Tara, and I'm a plaintiff attorney for Sydney Young.
My name is Lena Lou.
I'm Jason Smith.
The defense?
I'm Muscat Ali, and these are my co-counsels, Alexander Barnardi and Lindsay Brennan. We're defending Riley Gardner.
All right. Is the plaintiff ready to give their opening statement?
Yes, Your Honor.
You may proceed.
May it please the court. My name is Lena Lou, and I'm a fellow plaintiff's attorney, along with, once again, my co-counselors, Tara Turpin and Jason Smith. The case we're talking of today is that of Sydney Young versus Riley Gardner. Our client, Sydney Young, was a girl that had ambitions, dreams, and hopes for a prosperous future, like many teenagers. Her talents and desires led in the direction of a successful career as a professional artist. However, she waved goodbye to that future, or rather, due to her injured arm she cannot wave, that future was simply ripped from her grasp. On the early morning of May 12, 2007, after attending a party at a friend's house, Sydney went with others to get some food. She was the front passenger of a 2006 Honda Accord driven by defendant Riley Gardner. The defendant lost control of the vehicle, sending it spiraling into a telephone pole. Consequently, Sydney was left with a crushed arm and hand, 3 broken ribs, and injured knee. Her impairments bring her torments as she continues in efforts to maintain a daily normal life, a life that may never be the same again. All of Sydney's sorrows were brought upon by the inattentiveness of the defendant on that evening. That is why we will prove that Riley Gardner is liable of negligence, and that negligence is the direct cause of Sydney's injuries. We will uncover that Riley Gardner violated city ordinance for texting while driving. He also disregarded the safety of passengers when he drove over the speed limit and paid little attention to the road. We win by a preponderance of evidence that Riley Gardner was at fault of more than 50% to the cause of the accident. Today, you will hear from 3 very reliable witnesses. Our first witness will be a very accredited accident reconstructionist. She is one of only 3 ACRTA accredited accident reconstructionists. Her name is Peyton Lancaster. Miss Lancaster, having many years of experience in this field, will corroborate that the defendant was in fact speeding based on tire marks found at the scene of the crime. She also established that messages sent from Riley's phone correspond to the timing of the crash. Next shall be Evan Simpson, who, having no affiliation whatsoever with either plaintiff or defense, is here to testify that he saw Riley Gardner speed, that he saw a green glow of a cell phone coming from within the driver's side of the vehicle, and that Riley Gardner not once even looked up minutes before the crash. Evan is the only witness to the accident outside the vehicle. Our last witness will be Miss Young herself, who will tell the occurrences to which resulted in her many injuries and pains, including Riley Gardner's failure to drive with due care by going at least 10 or 20 miles over the speed limit and sending electronic messages behind the wheel. Ladies and gentlemen, Riley Gardner took on the responsibility of Sydney Young's safety when she invited her into her vehicle. However, Riley's carelessness caused Miss Young more harm than she could ever imagine. We urge you to grant Sydney the relief that she deserves. We believe that after hearing the witnesses and evidence, the court will have to rule in favor of Sydney Young. Thank you.
Does the defense wish to give their opening statement now or reserve it till later?
Yes, Your Honor.
Go ahead.
Good morning, ladies and gentlemen of the jury. On the early morning of May 12th, 2007, there was a one-car accident on Wells Gate Parkway. And today we are here because my client was accused of negligent driving. However, you will hear that this accusation is wrong and that this incident was just an accident. The plaintiff is trying to pass the blame of her injuries onto the innocent, responsible high school student Riley Gardner. 3 students from Clearwater High School were passengers in the Honda Accord that hit a pole. Evidence and testimony will prove that the driver, Riley Gardner, was not driving negligently and is not responsible for the injuries attained. First, you will hear the testimony of Adrian Knight, a veteran police officer who has experience with countless numbers of accidents, an expert and a professional in his field, that Riley Gardner was being a responsible driver based on the evidence at the scene. You will also hear from Officer Knight that Riley Gardner, the driver of the vehicle, was going below the speed limit prior to the accident. You will hear from his testimony that the text messages exchanged inside of the car before the accident were made by 2 different authors. Moreover, you will hear, based on the blood alcohol test obtained by expert Adrian Knight, that Riley Gardner was clearly not drinking. Our second witness, the defendant herself, Riley Gardner, will testify to the fact that she does not drink because of personal matters. You will hear Ms. Gardner, in her own words, testify that she's not a negligent driver because she took safety precautions when she got into the car. Finally, you will hear the testimony of Alex Williams, the backseat passenger, who supported Riley Gardner's claim of taking safety measures as a driver. Accidents happen, ladies and gentlemen. That's life. Do not let the plaintiff pass the blame on my client, an innocent, responsible driver. She's a responsible high school student who was just looking out for her friends, both inside and outside of the car. After hearing the evidence, I ask you to find Riley Gardner not negligent on all charges and not responsible for monetary damages. This was just an accident. Please do not let this ruin Riley Gardner's record because the plaintiff decided to pass the blame for her own injuries. Thank you.
Is the plaintiff prepared to call their first witness?
I call Peyton Lancaster to the stand.
Right up here, please. Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Be seated, please.
Please state your name and occupation for the court.
I'm Peyton Lancaster, and I'm an accident reconstructionist.
Elaborate exactly on what an accident reconstructionist does.
Well, I utilize equations to determine the time, speed, distance, and velocity of the collision.
Where did you go to college?
I went to the University of Superior for my bachelor's degree and my master's of science degree, and I'm also a member of the Society of Mechanical Engineers.
Do you have any other specific training?
Yes, I am also a member of the ACRTA.
What exactly is the ACRTA?
Well, it is the Accredited Coalition of Reconstruction for Traffic Accidents.
Are you accredited?
Yes.
How long have you been accredited for?
I've been accredited for 4 years.
What process exactly do you have to go through to become an accident reconstructionist?
Well, you must take a practical test, which I did not pass the first 2 times.
How many people are there that are accredited through the ACRTA?
There are about 650 people accredited throughout the U.S. and Japan.
Did you investigate the accident that occurred on May 12th, 2007 on Wells Gate Parkway?
Yes.
What sort of data did you use to investigate this accident?
I used pictures.
And what exactly do these pictures tell you about the accident?
I noticed there were skids that were 73 feet long, which indicate that the driver was going at least 43 miles per hour when the speed limit is 35 miles per hour.
Did you review Riley Gardner's cell phone records from the accident?
Yes.
And can you infer that the cell phone records coincide with the time of the accident?
Yes.
Thank you, Your Honor. No further questions.
Cross-examination.
Mrs. Lancaster. I'm going to ask you a few yes or no questions, and I'd like you to respond. Yes or no, please. You stated that you were not accepted or accredited by the ACRTA the first 2 times you took the exam,
Yes.
and so you failed the first 2 times.
Yes.
And is it true that the exam is a staged collision, such as the one which you investigated within this case? It's the same type?
Yes.
So you failed a collision test twice?
Yes.
Okay, thank you. And as an accident reconstructionist, you said it's the focus of your job to investigate and evaluate the scene, is it not?
Yes.
And did you ever visit this scene?
No, it had rained and I didn't find out
Thank you.
until
Yes or
2
no
days
was
later.
good. Thank you. And have you ever given your deposition before?
3 times
And for whom did you give it?
for the plaintiff.
Objection, Your Honor, relevance.
Your Honor, it goes towards bias.
Pardon me?
It goes towards bias, as she works for the plaintiff firms in the past.
Overruled.
Thank you. So have you ever given your deposition before?
Yes, 3 times.
And whom was it for?
For the plaintiff.
And who are you working for today?
The plaintiff.
Are you paid for your time today?
Yes.
How much are you paid?
$12.
Excuse me?
Or $250 per hour.
Okay, thank you. No further questions?
Redirect?
No, Your Honor.
All right. You may step down.
Call Evan Simpson to the stand.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Please state your name and occupation for the court.
My name is Evan Simpson. I work at Madison County Medical Center and sometimes wait tables at my grandma's restaurant, the Silver Spoon.
And how old are you, Evan?
I'm 37 years old.
Where were you on May 12, 2007?
My friend Joe and I were going to buy lottery tickets from a nearby service station.
Is Joe all who you were with?
Yeah, just my friend Joe and me.
Were you driving?
No, my car was in the shop, so my friend Joe was driving his black minivan.
How careful are you with driving?
I'm a pretty careful driver, even though I wasn't driving. I've been called the world's best backseat driver, so I'm still paying attention to the road and for oncoming traffic like you're supposed to when you're driving.
Oh, okay, so what exactly did you see on your way to the store?
As we were passing through the intersection of Pitts Avenue and Wells Gate, I saw a car coming southbound towards us.
Could you see inside this vehicle?
Yeah, the area was pretty well lit by a street lamp, and I could make out a faint green glow inside the car that...
Objection, non-responsive.
Response to the objection?
I don't have one, I'm sorry.
It's overruled. Go ahead.
could you restate the question, please?
What did you see? What did you see while looking inside the defense vehicle?
Well, I could see a faint green glow, and the area was pretty well lit.
What would you say the green glow was? Again?
It looked to me a lot like a cell phone being used at night.
How fast would you say the approaching vehicle was going?
I would say the vehicle was going about 10 miles an hour above the speed limit, so around 45 miles an hour.
Between the time the car that you were in and the defendant's vehicle passed the intersection, were there any conditional changes to the roadway?
No, they skidded through the intersection only seconds after we had passed through, so they were obviously going faster than we had originally thought.
Do you have any affiliation with either the plaintiff or the defendant in this case?
I don't know either of them.
And do you have any incentive to lie in this case?
No, I was just a good citizen doing his job of reporting an accident that I saw.
No further questions, Your Honor.
Last examination.
Have you told the truth here today?
Yes, I have.
And have you ever been, isn't it true that you have been found guilty of embezzlement before?
Yeah, but that was a dark time in my life. I don't really like to think about
Yes
it
and
anymore.
no, please. Were you convicted of embezzlement before?
Yes.
Thank you. Okay. And isn't it true that this embezzlement was at the Silver Spoon's diner?
Yes, it was.
Isn't it also true that you work with your grandma at this Silver Spoon diner?
I do. I don't see how that... Who?
Isn't
work
it
for.
true that your grandma is the person you stole from for this embezzlement?
Yes, she obviously forgives
you.
me, so.
No, going back to the beginning. Isn't it true that the accident occurred in the middle of the night?
Yes, middle of the night, early morning.
Thank you. Isn't it true that it was dark outside?
Yeah, but like I said
Thank
earlier,
you.
the area was pretty well lit.
Isn't it true that the light you saw inside the car could have been from an iPod, dashboard, GPS system? Isn't it possible that it could not have been a cell phone?
It might be possible, but like
Yes or
I
no,
said, I'm
please?
pretty sure it's a cell phone.
Did you see an actual cell phone?
No, but I know what a cell phone looks like when it's used at night.
And so there is no possibility that it could have been a GPS system, an iPod, or a dashboard?
I've already said it could be, but what I thought I saw was a
Thank
cell
you. That's
phone.
good. Thank you. Isn't it also true that you have... Oh, okay. You gave a statement earlier that you thought the car was speeding 10 above or so?
Yes, around that.
Okay. Have you ever taken any courses or been certified in in the car's vehicle movement, the speed of it?
No, but I don't need to be an expert to know that a car is
Thank
going
you.
faster than the speed limit.
But have you ever been certified to know the exact speed?
No.
Thank you. That's all, Your Honor.
You direct?
No, thank you, Your Honor.
You may step down. Next witness.
I did call Sydney Young.
Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Be seated, please.
State your name for the court.
Sydney Young.
How old are you, Sydney?
I'm 18.
Do you remember this evening of May 11th?
Yes, I do.
Where were you on that night?
I was at Austin Kramer's party.
What was this party for?
It was for some sports championship. I'm not really into sports. I'm more keeping to myself to draw.
What exactly happened at this party?
Well, a couple of us got hungry and decided to go get something to eat.
Who's a couple of us?
Riley Gardner, who drove, Alex Williams, who was in the back seat, and myself.
How well do you know Riley and Alex?
Well, I've seen Alex a couple other times, but me and Riley were getting closer at the time.
So, before you got into the car, what did you know of Riley's driving habits?
Oh, I thought he was an okay driver until he told me to put my seatbelt on. Then I thought he knew he was a bad driver.
What happened in the car?
Riley was texting his girlfriend. He was very frustrated with her. Then he kind of tossed the phone at me. This was all after he told me to put my seatbelt on.
What happened next?
Riley lost control of the vehicle.
Were you hurt by this crash?
Yes, I was, really severely. My right hand, it was crushed and mangled. I can't do anything with it.
Your Honor, non-responsive.
You have a response to the objection?
I believe the witness has the right to tell the kind of injury she sustained from such a big crash.
Well, the question called for a yes or no answer. You can ask another question. So she's indicated yes, but then she continued to elaborate. So ask another question. The objection sustained.
Can you elaborate on those injuries?
My right hand was crushed, and I can't do anything with it now. And my 3 ribs were broken, and my lower back has lots of pain. I can't sit for long periods of time. I also have knee pain, and I get really bad headaches that medicine won't help.
Did you have any plans for the future?
Yes, I did. I wanted to become a professional cartoon artist.
How will these injuries affect those plans?
Well, now I can't sit for long periods of time without lots of pain, and I can't use my right hand, which was my dominant hand.
Can you tell me about what Riley sent you in MySpace?
He sent me a comment.
Objection, Your Honor. Hearsay.
Response?
Well, Miss Young obviously got something from Riley Gardner that she herself had read, so I believe this is right out of what she herself saw.
It's an outside evidence.
Pardon me?
It's an outside evidence used in.
Well, the objections for hearsay, however, the stipulations in the pretrial statement allow the admission of the text messages So the witness is able to testify as it relates to that because of the stipulation.
This is MySpace, not the text messages.
Is that what your question was, MySpace?
Yeah.
Oh, I missed that one. Good point. Objection sustained.
Then I have no further questions, Your
All
Honor.
right. Redirect, or cross-examination, excuse me.
Is it true you attended Austin Kramer's after party?
Yes, I did.
And you didn't know what this after party was for?
I know it was for some sports championship, but that's all.
Okay, so it was for a celebration. Why did you go if you didn't go to the game?
I got invited.
Okay. And is it also true that you isolate yourself from these kinds of events?
Yes, I keep to myself so I can draw.
And how are you acquainted with Alex Williams?
I've seen him at previous parties.
All right. So is it true that he's known to supply alcohol to you previous?
Yes.
So is it true you attended this party and was illegally drinking as a minor?
Yes.
Your Honor, relevance?
What's your response?
And during the night, her judgment would be imperable because she was drinking.
Overruled.
Thank you. Who did you leave the party with?
I left with Riley Gardner and Alex Williams.
And you said that Riley told you to put on a seatbelt?
Yes, he did.
And you felt that it was because he felt he was a bad driver?
Yes.
Could it have been that he wanted the safety for you?
Might have been, but he never checked to make sure either.
Okay, and you feel that was his responsibility?
Well, I had it on.
No further questions.
Redirect.
No, Your Honor.
You may step down. You have any other witnesses?
No.
So you resting? Defense, wish to call a witness?
We would like to call Riley Gardner to the stand, please.
Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Be seated, please. Go ahead.
Good morning.
Good morning.
Please state and spell your last name for the record.
Riley Gardner, Gardner.
How old are you?
I'm 18.
Do you go to school?
Yeah, Clearwater High.
And do you work?
Yeah, I have an early morning paper route. I have to get up at 4 a.m.
Why don't you work in the afternoon?
I take care of my sisters in the afternoon.
Okay. Well, let me draw your attention to the night of May 11th, 2007, the night of the district championship game for your school. Did you attend this game?
Yeah.
Did your team win?
Yeah.
To celebrate this victory, what did you do anything?
I went to Austin's after party.
And was there drinking at this party?
Yeah, about half the kids.
And were you drinking?
No.
Why not?
My dad was an alcoholic, and he died while driving drunk, so I stay away from that.
Did you try to get out of this situation?
Yeah, I felt really uncomfortable.
So what did you do?
I suggested to a couple people that we should leave and go get some food.
And who were these people?
Sydney Young and Alex William.
Was there a particular reason you chose them?
Well, they were pretty drunk. Whenever my dad was drunk, my mom would try and get him to eat because food makes the alcohol metabolize faster. So I figured I should get them something to eat.
Were you the driver?
Yes.
Did anything occur as you were pulling out?
Well, I got a text message from Taylor.
And who is Taylor?
My boyfriend.
Did you respond to this text message?
No.
What did you do with your phone?
I gave the phone to Sydney and asked her to reply NTWD.
What does that mean?
It means no text while driving.
What happened next?
I lost control of the car.
Do you know if Sydney had a chance to reply to the text message?
I have no idea.
Okay. Did anyone get hurt?
Yeah, Sydney got hurt pretty badly.
And how do you feel about that?
I feel bad for Sydney. I know she blames me, but it was just an accident. I really don't feel it was my fault.
And let's rewind back to the beginning. When you got into the car, did you take any safety precautions?
I told everyone to put their seatbelts on.
No more questions, Your Honor.
Cross-examination?
You attended a party at Austin Kramer's house on May 11th, 2007, correct?
Yeah.
And there was drinking going on at this party, correct?
Yeah, it made me really uncomfortable.
Well, are you aware that the legal drinking age in the state of Superior is 21?
Of course.
Is it true that you've had 2 speeding tickets in your driving history?
I have to drive pretty...
Oh, no, sorry.
You may answer.
I have to drive pretty fast to get to school on time because of my paper route, and unfortunately I've gotten 2 speeding tickets.
Did you suggest to drive Sydney Young to go get something to eat after the party?
Yeah.
When you invited Sydney and Alex into your car, you took responsibility to drive safely and with due care, correct?
Yeah. I told them to put their seatbelts on.
But you didn't check to make sure that Sydney put her seatbelt on, correct?
No, I did not.
Is it also true that you were texting while driving?
No.
Have you ever texted while driving before?
I have previously, and I regret it now.
Well, are you aware that by city ordinance, sending, reading, or writing a text message is against city ordinance?
Well, I didn't know reading was.
Is it also true that you were not comfortable driving your 5-speed Honda Accord?
I was getting used to it.
So even though you weren't comfortable driving your car, you still invited Sydney and Alex to ride with you, correct?
Yeah, but it wasn't really that big a deal. I could drive it just fine. I have my license.
Is it also true that you told authorities that you're not exactly sure what happened during the accident?
Accidents go so fast. It's hard to recall all the tiny details.
Thank you, Your Honor. No further questions.
Direct.
It was acknowledged earlier that text messages were sent from your phone. Was it you who sent them?
No.
And who did?
I'd assume Sydney. I gave the phone to her.
And why did you give it to her?
Because I didn't want to text while driving.
And earlier, it was said that it was your responsibility to make sure they did it. But you did tell them to put on their seatbelt, right?
Yeah, right when we got in the car.
Thank you. No more questions, Taylor.
You may step down.
Thank you.
Next witness.
Your Honor, can I call Alex Williams and say?
Raise your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Please sit, please.
Good morning, Alex.
Good morning.
Can you please state your name and spell it for the record?
My name is Alex Williams. Williams.
How old are you, Alex?
I'm 17.
And what school do you attend?
Clearwater High School.
Right. I'm going to take you back to the night of May 11th. Where were you earlier that night?
A baseball game.
Right. And where'd you go afterwards?
Austin Kramer's party.
And was there drinking there?
Yes, there was.
And you had beer in your possession. How many?
I had about 8 beers.
And how many did you actually consume?
I consumed about 3 to 4.
Do you consider that a lot for yourself?
No.
And so your judgment was pretty clear that night, correct?
Yes, it was.
And who'd you leave the party with?
I left the party with Riley Gardner and Sydney Young.
And who was driving?
Riley Gardner was driving.
And was he drinking at all that night?
No, Riley was sober.
And where were you seated within the car?
I was sitting behind Riley, the driver.
And within this position, do you think that you were speeding at all?
No.
And was Sydney in the passenger seat then?
Yes, Sydney was in the passenger seat.
And at any time on the ride, did Sydney take her seatbelt off?
Yes, she did.
And why did she put it on in the first place?
Sydney put her belt on in the first place because Riley told her to do so.
Did she return back to the front of the car then?
Yes, she did.
And what did you observe when she did this?
That she took her seatbelt off?
No, when she returned to the front, back in forward position. Was anything, Riley give
I'm sorry, Riley threw the phone to Sydney.
And why do you think this?
I believe Riley didn't want to text while driving.
So Riley did not have the phone in his possession at the exact time of the crash.
No, Riley didn't.
All right, no further questions, Your Honor.
Cross-examination.
Ms. Williams, you attended Austin Kramer's party on the night of May 11th, correct?
Yes, I did.
Now, you said there was alcohol available, and you did have some of that alcohol?
Yes, I brought my own alcohol.
You do realize the legal drinking age in the state of Superior, correct?
Yes, I do.
You're obviously below that.
Yes, I am.
That night, Riley invited you and Sydney along to get some food, correct?
Yes, she did.
You sat in the back seat, correct?
Yes, I did.
It was around midnight, right?
Actually, about 12:30.
Would you say it was pretty dark outside, though?
Yes, I would say so.
You claim to have seen a shadow cross in front of the car?
Yes, I did.
So you're telling me you saw a shadow cross in front of the car from the back seat at midnight, of which you agreed was dark outside, after consuming alcohol?
Yes, well, they do have street lamps that illuminate the area.
Now, you stated you have no idea why Riley lost control of the vehicle, correct?
No, I don't.
Yes or no? Riley did, in fact, send a text message while driving that evening.
Yes, but not while she was driving.
Thank you. Now, would you agree that Riley disregarded the safety of her passengers, you and Miss Young, by doing so?
No, I wouldn't agree.
You believe that texting while driving is okay, then? You stated that
I believe she
did
had
text,
our safety in consideration by asking us to put our seatbelt on.
but she did send a text while driving. with
Yes,
you
but
in
prior to
vehicle.
the accident.
All right. No further questions.
Be direct.
When you got in the car, Riley asked you to put your seatbelt on.
Yes, she did.
And then did Riley take Sydney's seatbelt off himself?
No, that was Sydney's own doing.
Okay, and when he sent that text message, it was when he was pulling out of the driveway, is that correct?
Yes.
And where did the accident actually occur?
Well after that on Wellsgate Avenue.
All right, no further questions.
All right, you may step down.
Thank you.
Next witness.
You guys call Adrian Knight to the scene.
Raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Be seated, please.
Mr. Knight, can you please state your name and spell your last name for the record?
It's Adrian Knight, Knight.
Thank you. Mr. Knight, what's your occupation?
I'm a police officer.
And how did you come to have this position? Can you share with me your background, please?
Well, I went to Police Academy in Georgia. I did some time as a security officer, also as a highway patrolman, and then finally I took a training course for accident reconstruction, and it helped me land my job at the Clearwater Police Department.
Okay, how long did you work as a highway patrolman?
For, I believe, 4 years.
Can you share with me, did you learn a lot while you had this job?
Yes, in fact, oftentimes I'd be the senior officer on the case, and I'm first response because I'm patrolling, and I saw firsthand the effects of reckless driving and careless driving.
Okay, thank you. With this reckless and careless driving, does this mean a lot to you?
Oh, very much so. I have a program for it.
Oh, can you tell me about your program, please?
Well, the program is called Attention Equals Alive. It's very similar to Just Say No or the DARE program, and it involves basically people who drive tend to not to respond to an accident because they're distracted by reading a text message or anything that could have been outside the car. And I very much support the thought that you should pay attention while you're driving.
And you started this campaign?
Yes, I did it myself.
Do you get help from this campaign from outside sources?
The legislature supports us.
Okay. Your Honor, I move to certify Adrian Knight as an expert in an accident investigation.
It's been stipulated, too, as part of the pretrial statement.
Okay, thank you, Your Honor. Can I draw your attention now to the evening of May 12, 2007? Were you called to any accidents that evening?
Yes, I was.
What was your first act upon arriving to this accident?
Well, I surveyed the scene, and I immediately talked to the two EMTs.
For your investigation, did you gather any information from them?
Well, they took Sydney off to the hospital, and they said that
Let me pause you here. Who's Sydney?
Sydney Young is the person who was injured in the accident.
Oh, how many people were in the car?
There was 3.
Okay. So let me bring you back then. What did the EMT share with you?
They said that the other 2 were still on scene, which I later interviewed, and that all standard procedures were taken and nothing was wrong.
Okay, thank you. So you said you interviewed the witnesses for your investigation. Did you gather any information from one of them or both of them?
Yes, ma'am, I did.
Who did you interview first?
Alex Williams.
And what information could you gather from him?
Well, he had told me that Riley Gardner, passed off the cell phone to Sydney to text.
Okay, what is text messaging? I don't know that all of us are familiar with it. Can you please share with me what it is?
Well, text messaging is when you have a cellular device, and the numbers each represent a letter. And so the number 2 represents the letter A, B, and C. And so in order to type, you have to type in 3 times to get to the letter C or B or A. And then you have to complete an entire sentence this way, and then send it via telephone to another telephone.
Okay, thank you. So there was text messaging going on in this car then?
From what Alex said earlier in the night, yes.
Okay. Did he share with you who the text messaging was between?
Yes, he did.
And who was it?
It was between Riley and her significant other.
Okay. Did you interview Riley then about this as well?
Yes, I did.
Did she have anything to say about the text messaging?
She said it was just that her boyfriend was getting upset about spending so much time with other people.
Okay. Did she send text messages?
I believe so, one earlier in the evening.
Okay. Thank you. What did you do after you interviewed these witnesses?
I then proceeded to take Riley Gardner to the hospital.
Okay. What was your purpose of taking her to the hospital?
Well, to complete my report, I have to take the blood alcohol level of the driver and anyone else involved in the case. So I took the blood alcohol level of the driver, which returned there was no traceable amounts of alcohol. And then Sydney Young returned, she was at a 0.9, I believe.
0.9?
0.09, excuse me.
Okay, thank you. So the standard procedure for you to measure the blood alcohol contents when you're investigating scenes?
Yes, ma'am, it is.
And so at what time were these blood alcohol contents taken?
I believe one was taken at 3:20, that would be Sydney's, and then 3:30 was Riley Gardner's.
Okay, so that's a significant time after the accident, is that true?
Yes, ma'am, it is.
And Sydney's was still measured at 0.09, which is legally intoxicated?
Very much so, yes it is.
Okay, thank you. Did you interview Sydney then at the hospital?
I tried to, but she wasn't being very helpful at all. I think it was because she was still on drugs, the pain medication.
And obviously still under the influence. Okay, thank you. Let me bring your attention now back to this texting. Have you ever covered a case that had texting involved with the accident?
Yes, I have.
Okay, and could you learn anything from that?
Well, like I said earlier, most of the time when someone's preoccupied with texting, they don't have any response to the accident or try to even correct the vehicle. Sometimes it's like they just hit a wall and they don't know it's really there.
Okay, thank you. And then you work with this also in your campaign.
Yes, it's the main focus of the campaign.
So you're very familiar with the effects that texting can have upon a driver?
Yes, I am.
Okay. Your Honor, may I approach the bench to show you Exhibit 2? Which is the text messaging records.
You don't need to approach the bench to do that.
Okay. May I approach the witness then?
All right.
Thank you.
You're welcome. I've just handed you a certified copy of the text messages from this evening. Have you seen these before?
Yes, I have. I've obtained them myself.
So you investigated these prior for your investigation?
Yes, I have when I did an investigation earlier, I have a friend at the phone company who, to make sure I wasn't missing anything, I obtained her records.
Okay, so these are in fact the same copies that you obtained?
Yes, ma'am, they are.
Okay, Your Honor, I'm moving for the admission of Exhibit 2 into evidence at this time. The authenticity of this exhibit has been stipulated.
Any objection?
No, Your Honor.
All right. Well, the exhibit's admitted into evidence.
Thank you, Your Honor. In reviewing these messages, what information could you gather for your investigation?
Well, I noticed most of them were from Taylor, which is the boyfriend at the time.
Okay, and the text, the first couple texts, what was the time frame that they were sent at?
They were sent around 6:09, so around 6 o'clock, I mean 6 and 7, the first couple.
Okay, are there any sent from Riley earlier in this evening?
Yes, earlier.
Okay, and what did you gather from these texts sent from her? Could you tell any patterns about them?
She tended to use a lot of like letters and words, and then also punctuation. She uses 3 periods after something.
Okay, later in the evening, were there messages sent by her?
Not really, no. There was 2.
Well, what was the first one?
The first one was very short, but similar to her style, which was she used abbreviated letters a lot of the time. And it said NTWD exclamation point.
Okay, thank you. And then what was the last text message sent from her phone?
The last text message was a complete sentence that said, "No, period, period, period. I am happier with Sydney. Leave me alone, please. Good night. ... Bye."
Is that similar to what she has been using for the rest of this evening?
No, all the rest of them are abbreviated. They're cut down, and they're very short.
So what information, or what could you conclude from this information?
Well, from my experience with text messages and anything I've done in the past, it looks as though the person who was originally texting earlier, which I believe to be Riley, wasn't texting at the time of the accident. This is a full sentence, and it's not abbreviated at all, and many of these words could be abbreviated in the common texting phrase.
Okay, so you conclude then that...
Oh, I conclude that Riley was not texting, at least not for this one, the last one.
And does this text message coincide with the time of the accident?
Yes, it does, actually. It's right at the same time.
Okay, but do you believe it was sent by Riley?
I do not.
Okay, thank you. I move to publish Exhibit 2 as evidence to the jury.
Go ahead.
Thank you.
Thank you. Okay, so could you gather any other information to say that, besides text message, to say that Riley wasn't distracted? Did you, or was that
Yes, I did, actually.
Okay, what was it?
Well, see, there was skid marks going all the way through the intersection, showing that she had plenty of time and actually did act upon trying to avoid an accident.
Okay. Did these skid marks tell you any other information for your investigation?
You can calculate the speed of a car from the skid marks.
And did you do this?
Yes, I did.
What did you calculate the speed to be?
I calculated from my experience that she was traveling at least 5 miles per hour under the speed limit, going 30 miles per hour in a 35 mile per hour zone.
Okay, thank you. So could you come up with a cause for this accident?
Scientifically, no. I couldn't see anything.
Do you think then the accident was caused by operator error?
Not from my understanding of the case, not at all.
Okay, so you can conclude then that it was not Riley's fault?
In my opinion, no. I don't believe it was Riley's fault at all.
And how did you base this, that it wasn't operator error?
Well, there was a pre-accident response of the skid marks. And, I mean, she also earlier in the evening said put on her seatbelt. So, I mean, it shows that she's aware of her surroundings and trying to stop this accident before it even happened. So, I don't believe it was her at all, no.
Okay, thank you. No further questions.
Cross-examination?
Mr. Knight, you interviewed Sydney Young on the night of the accident, correct?
Yes, sir, I did.
And this was shortly after the accident?
About an hour, 2 hours.
Okay, so isn't it shortly after the accident that mutilated Miss Young's hand and broke several of her ribs?
Yes.
So isn't it very possible that during your interview, Miss Young could have been in shock or otherwise a state of impairment to even be answering your questions?
Your Honor, I'm sorry, I cannot understand or hear what he's saying.
Sorry.
Yes, you speak up, please.
Yes, okay. So isn't it very possible that during your interview, Miss Young could have been in a state of shock or otherwise impaired to even be answering your questions?
Yes, that is correct.
While investigating the scene, you took measurements of the skid marks, correct?
Yes, sir, I did.
And these measured to be about 73 feet long, correct?
That is what I found, yes.
And you also investigated the telephone pole, correct?
The utility pole, yes, I did.
And you found this to be several feet away from the curb, correct?
Correct.
And you took measurements of the curb, correct?
I believe so, yes.
This curb proved to measure about several feet high, or several inches high, correct?
Yes, sir, it did.
So even after carefully evaluating all this evidence, you still found the car to be traveling 5 miles per hour under the speed limit, or 30 miles per hour.
Yep, from my experience as a highway patrolman, that's what I concluded, yes.
Okay. Your Honor, may I approach the opposing counsel with proposed exhibit 1A?
Go ahead.
Your Honor, may I approach the witness?
For what purpose?
I'm trying to, this is proposed exhibit 1A, it's the uniform traffic crash report to,
Want to present that to the witness?
yes.
Go
yes.
ahead.
Thank you, sir.
Do you recognize this exhibit, proposed exhibit?
Yes, sir, I do.
What is it?
It's my report of the accident.
And you filled this report out, correct?
I did, yes.
And would you say it's an accurate diagram of the evidence you gathered in the day of the accident?
Yes, I do.
Your Honor, plaintiff asks proposed exhibit 1A be admitted into evidence.
Any objection?
Lack of foundation.
Pardon me?
Lack of foundation.
I believe that I've laid out proper foundation for it. He's admitted to filling it out, and that it has been accurate information on the report. So.
Do you have something else you wanted to say? Okay. The foundation has been established. It is a allowable exhibit under the pretrial statement, and therefore it's admissible.
Mr. Knight, according to Exhibit 1A, you gathered that the defendant vehicle was traveling 2005, or was a 2005 Honda Accord, correct?
Yes, sir, I did.
And when in actuality it was a 2006 Honda Accord?
I'm unaware of that.
According to this would go to prove that Officer Knight has recorded improper information, or information is not correct that he recorded on the police report.
Using it for impeachment?
The report is stipulated to be correct.
Well, the report can be stipulated to be correct, but if it's at odds with his testimony, it's admissible to show that his testimony is not consistent with his report. So I'm going to allow it.
So the information you recorded was wrong, correct?
No, I don't believe so at all.
I believe so. Okay, no further questions, Your Honor. I'm sorry.
Redirect.
Do you remember giving a testimony about this case earlier today?
Yes, I do.
And did you testify that it was a 2006 Honda Accord?
I believe so.
Okay. If I showed you your testimony, would it help refresh your memory?
Yes, it would.
Your Honor, may I approach the witness with his statement?
For purposes of a refresh and recollection, it's not permitted under the rules.
It's in the rules, I'm pretty sure.
Well, I'm ruling you can't.
Okay. Okay, then no further questions. Right.
You may step down.
All right.
Do you have any further witnesses?
No, Your Honor.
All right. Are you prepared to give your closing argument?
We are, Your Honor.
Go ahead.
May it please the court. Ladies and gentlemen of the jury, Your Honor, many things have been proven by the plaintiff today. Most importantly, we have proved that the negligence portrayed by defendant Riley Gardner to be the proximate cause of Sidney Young's injuries, including several broken ribs and a mutilated arm. We as a plaintiff would like to overview many of the statements you have heard today and depict the fact from fiction. The first witness that was heard from us today was the educated Peyton Lancaster, a stipulated expert and accident reconstructionist of the state of Superior. Some of the most important information obtained from Miss Gardner, or from Miss Lancaster, include the truth about Miss Gardner's acted and the night of the accident. Miss Lancaster has stated that through the evidence she has obtained, she can infer beyond reasonable doubt that on the night of the accident, the defendant was traveling several miles over the speed limit. The next witness you heard from was Mr. Evan Simpson, who had plenty of reasons not to testify in court today, and despite these reasons, earlier was testifying to the truth. The truth that Mr. Gardner's vehicle was traveling several miles per hour over the speed limit. He recognized the entire time that Mr. Riley Gardner had never looked up once, ladies and gentlemen. Also, perhaps the most valuable information obtained from Mr. Gardner is that the driving conditions of Mr. Riley Gardner had remained the same between the time that the very car Evan Simpson was in and Mr. Riley Gardner's vehicle passed the intersection. Now to the defendant, Adrian Knight. Adrian Knight cannot even get the year of the car correct, ladies and gentlemen. And he himself has also stated that teenagers who drive while texting are at a significantly higher percent of accident than teenagers at the time. You also heard from the defense witness, Alex Williams, who testified that before the crash accident, he remembered to see a black figure protruding from the vehicle. Now, it may have been the massive amount of alcohol consumed by this, but as a generalization, you do not come across shadow figures anywhere short of Stephen King books. Now we come to the defendant, Riley Gardner, who prior to this case has had several speeding tickets. This being said, shouldn't be enough to personify that Mr. Gardner's past negligence in the very field of driving negligence. We have had a total of 2 witnesses and an expert feel completely confident that Miss Riley Gardner was certainly speeding on the night of the accident. Possibly the most crucial flaw in the fairy tale reality portrayed by the defense today is that Mr. Gardner actually asked Sidney Young to come into the vehicle with him. He beckoned her occupancy into this vehicle, and therefore he took responsibility for her safety, or rather took advantage of responsibility for her safety, and placed it within his own hands. The final witness for the plaintiff heard was witness Sidney Young, another witness to testify to the speeding of the defendant, another witness to testify to the overall ignominious negligence of Mr. Riley Gardner. The innocent Sidney Young, who now, because of the carelessness of the defendant, has had her planned career and future aspirations torn from her now crippled grip. Thank you, Your Honor.
Defense?
Ladies and gentlemen of the jury, you have just been asked to feel pity for the plaintiff and her injuries. But this pity comes at the cost of my client. How sorry can we feel when it was indeed the plaintiff who was the one responsible for placing herself into the position she did that evening? And now the plaintiff has stood before you and tried to pass the blame for the events of that evening onto my client, Riley Gardner, by calling Riley negligent. Ladies and gentlemen, you have heard, though, from an eyewitness and passenger, Alex Williams, and from Riley Gardner herself, that she told the plaintiff to buckle up. But the plaintiff chose to take his seatbelt off. Neglecting to wear a seatbelt while sitting in the passenger seat of a car is defined as a civil infraction and is considered evidence of negligence in Madison County. Ladies and gentlemen, it is illegal not to wear a seatbelt while seated in the passenger seat of a car. You have heard that Riley Gardner was not speeding from Adrian Knight, a veteran police officer and an expert in accident investigation. Now, you've heard opposing counsel try and discredit him by claiming that he cannot get the year of a car straight. But in fact, in his testimony, he never stated what year the car was. He only claimed it to be a newer model. Now, Riley Gardner may have been confused as to the year of the car, but that was only within her statement, not within Adrian Knight's. You've heard also from the passenger, Alex Williams, who was inside the car, that he did not feel that they were speeding. and he was not particularly good friends with either one of the other passengers in the car. So he did not have room or, evidence to be biased in this regard. You've heard that the plaintiff has a reputation for partying. She didn't even know what the party was for, and yet she went and she admitted to drinking illegally underage. You've heard that Riley Gardner chose not to drink, and she was not being careless. She herself admitted that, and Alex Williams, the eyewitness and passenger, also admitted that. You've also heard that Riley Gardner was not in possession of the phone at the time of the accident. Riley Gardner herself claimed to have passed the phone to Sydney. Her statement was backed up by the statement of Alex Williams, and Adrian Knight, the expert in investigation, also claimed that it appeared from the language of the text that a different hand was holding the phone at the time of the accident. You have the evidence in front of you of the text messages, and you can see yourself the difference in the feel of language. From all the testimony you have heard and the evidence you have been shown, it is clear that the plaintiff was acting irresponsibly and negligently. The plaintiff went to a celebratory party not knowing what it was in celebration of for the purpose of drinking. The plaintiff chose to drink, chose to get into the car, and chose to take her seatbelt off. Riley Gardner was at this party, but was sober, and she had her own seatbelt on and told those in her car to wear them as well. It was the behavior of the plaintiff that was negligent, not the behavior of Riley Gardner. Sydney is simply attempting to pass the blame. You have heard that the plaintiff witness, Peyton Lancaster, is employed by plaintiff's firms, that he has consistently worked for plaintiff firms. Obviously, it is in his best interest to speak well for the plaintiff firm today. Whereas Officer Knight, who is an unbiased expert involved in this case, testified that with his professional background and experience as a trooper, Riley was not distracted with text messaging, and with the hard facts of the skid marks, she clearly made a pre-crash response, which a distracted person could not have done. You've heard that Riley has lost her father to alcoholism. She knows what alcohol can and will do to a person. Riley is used to acting as an adult in her family, taking care of her siblings for her mother, in addition to working an early morning job. Ladies and gentlemen, you are looking at the all-American child. As you heard from two experts earlier, Riley Gardner was acting responsibly on the night of May 12, 2007. It was with best intentions that Riley drove the intoxicated plaintiff to get food. Now, the cause of the accident was said to be scientifically unclear, as you heard from two experts early in the trial. Accidents happen, ladies and gentlemen. I'm confident to say that everyone in this courtroom has experienced an accident. Perhaps the gravity may not be equal to the one we're dealing with today, but regardless, it does not change its element of form. Accidents happen, and what happened on May 12th was an accident. I ask you, ladies and gentlemen, not to allow the plaintiff to stand before you and blame this accident onto the responsible young student, Riley Gardner.
That concludes the testimony and evidence in this case. The jury will now retire to the jury room and deliberate on a verdict. We'll be back in a few minutes.
All rise.
Be seated, please. All right, at this time, we're going to let the judges and talk to you about what we saw, point out some things to you. But instead of going directly to the judges, I want to start with the sheriff here. His job is to keep time and all that sort of thing, so I'm going to let him make a few comments to you and how well you did with that.
Great job. I'll keep it very quick because I know a lot of lunch is approaching. Take your time. You've got 20 and 25 minutes to present and defend. Nobody was close. You had a lot of time. I'm getting the numbers here. You're at 5 minutes, 5.5 minutes. The longest we took was 16 minutes, and that was by you, and that was a nice job. It seems like, you want to get up here and get down as soon as you get there, but you have a lot of time. 5 minutes is a lot of time for an open, it's a lot of time for closing. You hit yours almost to the T at 5, and I would say that's near perfect. I wanted to put this 1 minute up all morning to let you know that it's a good use of your time. Take advantage of all the time you have. Practice that. But you did a great job. Thank you.
Thank you, Sheriff. Ms. Armstrong.
I thought you guys did a phenomenal job, and I said, I take a lot of notes here, and the vast majority of what I wrote down is very positive, and I'd love to sit here and spend the next 3 hours going over it with you. But that's not going to help you, and I know you got one more round, and some of you may be going to the regional, so I just want to give you just a little bit of advice. Just like the sheriff was saying, right, especially it seems in these rounds, at the beginning, everybody's on fast forward, and the openings can be really fast, and the first couple of witnesses can be extremely fast. And what you want to remember is that you all have been living with this fact pattern for a very long time. You've lived it, slept it, breathed it, everything. We know it because we prepared for this competition, but in normal trial practice, your juror doesn't know anything about the case. They don't know what kind of car it was. They might not even know if it was a car crash until you start with your opening. So it's important to slow down your questions. Make sure you're listening to the answers. Follow up on the answers if they. I know a lot of you have your questions written out, and that's good to be prepared. But you don't want to be locked into those written questions, so that if a witness gives you some really important piece of information, you miss it because you're focused on the next question you need to ask instead of the answer that you're getting. I thought the vast majority of the time that you all were presenting either your direct or cross or as a witness, that you had extremely good presence, and that your pace that you were keeping, especially once we got past those few first witnesses, that the pace really slowed down and we had a chance to absorb what everybody was saying. I was looking for a few more questions from some of the witnesses. Go through those fact patterns again, particularly if you're going to the regionals, and there's a few more questions you can ask. So many of you were so solid on asking the questions and getting them locked in on something that they can't deny saying because it's written in a written statement. But there were some other things in there too. For example, it was brought out that one of the last text messages was NTWD, and I thought, Alex, you did a great job of explaining. I think it was Lindsay. You explained what text messaging was. You had the witness do that, which is important because not everybody might know exactly what that means. But I was looking for what that stood for. I know what it is because I've read the pattern, but that's a key part of the defense in this case. Is he came right out and said, "I'm not going to text while driving," and so you might want to follow up on that. I just thought you did a phenomenal job, both groups. I think you're doing an amazing job here today, and good luck in your next round.
Mr. Strummers.
Thanks, Judge. I too thought you did an excellent job, and I made a lot of notes, and really everything was positive. I thought you guys really did a good job. But particularly like the witnesses, I know it's tough memorizing all those facts, but Josh, you did a very good job of memorizing. All the witnesses on both sides did a really good job. The other thing I liked about the opening and closing is you guys tied the opening, especially Lindsay, tied the opening and closing together. It's really important because you're telling a story to the jurors from the beginning to the end. So you really have to tie those together, and I thought you did a nice job of that. And Alex, when you objected to the MySpace question, and there were some issues on that, it really showed you were prepared. And I really appreciated that. And that was, you were really thinking on your feet. And that's what this whole exercise is about, thinking on your feet, and that's what we have to do as lawyers. The other thing, I think on the examinations, if you go on, Lindsay, you did a very nice job, as the sheriff said, that you took your time. You were slow. My comments were you're slow, methodical. You wanted to get what you wanted to get out, and you did a really nice job. And that was because you used the time available. I think we could all learn from that. I get rushed, and I want to get to my next thing, but you did a very nice job at that. All the groups, I noticed that you admitted evidence very well in the case. We've seen some problems with admitting evidence because it's difficult. What do you do? Lindsay did a nice job of admitting evidence and identifying it and laying it out there. So other than that, I really don't have any critical comments. I thought you all did a very nice job. I think the last comment I wanted to make, because I kind of was laughing to myself, you know, the judge said there was a question on whether this evidence could be admitted or not, and we're going to go into it or not. And the judge said, well, and you said, well, it's part of the rules. Yet, and the judge said, well, I'm ruling it's not. That happens to us occasionally. And you did a very nice job of not arguing and say, I understand, and you sit down. Because you don't want to argue with the judge. Judge made the ruling, you move on. And I thought you did a nice job at that.
Ms. Lane.
Thank you. Very, very, very nice job. You all did wonderfully. And you're to be congratulated on such a good performance. A couple of pointers perhaps for future rounds. First of all, speed. You've heard it a couple times already. Don't be in a hurry. It's not a race. You have plenty of time. Take your time when you're questioning a witness to ask that question clearly and give the witness enough time. The witnesses did very, very well giving good explanatory answers, but it's important for both sides, both the questioner and the witness, to take enough time because, as you know, you have plenty of it. Secondly, assume when you're making your presentation, you're telling a story to the jury, and assume your jury knows nothing. And start from that point in preparing your presentation. We actually do, but as Ms. Armstrong indicated, in real life, a jury doesn't. So maybe that will help you in future rounds in your presentation. Assume the jury, the judges know nothing, so that you can walk them through it and give a very, very thorough presentation. Finally, on cross-examination, one thing about cross-examination, focus, as it should be most of the time, is on impeaching the witness, showing what the witness, how the witness has made mistakes, or impeaching that witness's credibility, and that type of thing. Occasionally, on cross-examination, you can get something out of that witness that helps your case in a substantive way. You may get from that witness a fact that actually supports, if you're a plaintiff, for instance, supports your story, or if you're a defendant, supports your defense. So don't only look at it in terms of I guess, destroying a witness's credibility, but also look at that as an opportunity to get something out of a witness that can support your claim. So, food for thought for the future.
Mr. Keyes?
Thank you, Your Honor. That was an excellent presentation by all of you. You're all to be commended on the great job you did. Defense counsel, I had a concern. My concern was that I'd have you in court, in actual open court, about 8 or 9 years, because you were all so good.
You'll be retired then.
I won't be retired. You really were all very prepared. You asked the right questions. You listened to what your witnesses were saying. You thought out where you wanted to go with your questions. It was all very cohesive. That was great. I could go on all day about you. I will say one thing, and I will be critical because you were so good. One thing, if you're going to publish something to the jury, I wouldn't necessarily do it when you're going to start asking more questions, because when you publish it to the jury, you give us something to read. We're not going to be listening to what you say. You're at least going to have the jury, or at least one juror at a time, not listening to what your witness is testifying to. So wait until the end. I think that plaintiff did a nice job of that, of waiting until the end. So that was one bit of criticism. The only other thing I'd say, because I don't know how they handle regionals, but wait until the jury has fully left the box and and has arrived in the back room before you congregate and turn your back on us. It's just a little point, but that's something that I think you need to be aware of. As it relates to your witnesses, excellent job, witnesses. I mean, you're to be commended as well, because you really did come across, and that goes for the three of you as well. That was really a great job of doing witnesses. Your voice inflection is so important. You're expressive. You made me really believe that you were actual witnesses in the case, as opposed to just getting up and answering information. So that was terrific. From a plaintiff standpoint, you really hit what we wanted you to hit, was the fact that your plaintiff is somebody who's been very injured, and you played those injuries up, and that was a terrific job. That's something that you need to do, because at the end of the day, the reason that you're in here, both sides, is to persuade us. You're trying to persuade us one way or another, and sometimes we get so bogged down in the rules, we forget that our job is to persuade us that your case is better than the other side's case. So you did a great job of bringing out the fact that you had an injured person, because sympathy in a plaintiff's case can be a very, very major point, and you hit on that point. Terrific job.
Mr. Davidson.
I thought I really saw one of the really outstanding witness performances. Not being intimidated, you especially, and they took our things away, so I can't call it that. You were being attacked for, just yes or no. You stuck in there. You got in your digs, and that was really good. I thought, because sometimes the witness will sort of cave in and okay, yes or no. Sydney as a witness was very good. I liked the getting the emotion in there. I know you're not allowed to use accents and all this, but he did a good job there of almost being annoyed at times by these silly questions. That was good. The police officer was very good at staying on point and as someone said before, taking your time. That's very excellent. And not acting all pompous and I'm a policeman and doing my job and this is what's that. I also want to comment on the opening statement, your opening statement. I want you to know I got your joke about waving goodbye to the teacher, except her wing was broken. I think I went over some people's head, but I had a hard time not laughing. And then emphasizing the injuries, that was good. Because you had two things. First of all, you had to show that it was the other guy's fault, and that these injuries are going to be endured, and because it's a civil case, you're asking for money damages. It's not a guilt or innocence of whose fault, but you're just trying to get money for your client. Finally, the closing statement by the defendant was one of the best I've ever seen. Just point by point going through there, you talked to us, very little reliance on your notes. It was a very, very good job of wrapping it all up, and really, trying to show how this really wasn't your client's fault. Maybe there was an accident. Really excellent way to present that, I thought, from the facts that you had. Thanks.
And good luck in your future rounds.
Thank you, judges. I have just a few comments too, and like Mr. Davidson says, they took away our sheets. So I wrote down some names, but not everybody's, unfortunately, so I apologize for not calling you by name if I don't. First of all, I was impressed with both teams. I thought you did a very good job in your presentation, in your preparation. Witnesses, I think, have the toughest job because they're not supposed to have notes. And that leads me to my not letting you present to refresh recollection, is because under the rules here, the witness is supposed to testify from his memory and cannot read from something. So if I was to allow you to present their report to them to refresh their recollection, it's the same as if they'd taken it up there to the witness stand and read from it to begin with. So that's the rule I was referring to. You can present for a statement that's made for purposes of impeachment, but not to refresh recollection. So, and now, in the real world, you'd be able to do that. It's just the rules of the tournament that don't allow you to do that. So it would be, had this been a real case and the witness couldn't remember something, you can present anything to refresh the recollection. That's the rules of court, and so you would be all right to do that. I just couldn't let you do it here today. The opening statement, you did a good job. You hit the burden of proof, and you were setting forth exactly what it was you were intending to prove, which is what the purpose of an opening statement is. This is what I've got to do, and this is what I have to prove. And I think you did a very nice job with that. And the same thing with, is it Muscan?
Muscan.
Muscan? Okay. You did not rely on your notes. You spoke very well without, I mean, you looked at them, which is fine, but you spoke without reading them. I think which is extremely important for everybody. Because, you know, if you're talking to me, you're talking to a jury, and you're trying to convince them of something, if your head's down, looking, and you're not looking at them in the eye, you're not doing anything at all, except for just reading. So there's no communication. And that's what the lawyer's job is to do, is to communicate with the people who are going to make a decision. So you did a very nice job in that respect, and pointing out exactly what it was you intended to establish through your witnesses. I would point out in your cross-examination, though, that when a witness is being gratuitous, in other words, I think it was Josh was on the witness stand over there, and he did a very nice job, but you were trying to get him to answer yes or no, and he was elaborating. All you need to do is turn to the court and say, Judge, we instruct the witness to just answer my question. Because then it's up to his lawyer, the lawyers for that side, to come in and bring out anything else that they might want him to elaborate. So that's just the method by which it's done. Instead of arguing with him, I said yes or no, you look to me and you say, Judge, would you instruct the witness to answer the question, just answer the question and not elaborate any. And I would have sustained, or I would have instructed him to do that. Let's see, Elizabeth, very good job. Voice inflections, I thought, okay, this girl's going to be an actress when she gets older. Because she presented, she had an attitude, she just did like witnesses do. It wasn't, it wasn't overly aggressive, it wasn't, you just did a nice job. And young girl with blonde hair right behind you. Amber, okay, you're one I didn't write your name down, I'm sorry. You also came up here with an attitude, and it fit the witness that you were representing. It really did. And I think that, I think the other side could have taken advantage of that, actually, maybe in their closing argument, that, you had a chip on your shoulder, you had something to prove on this whole thing, that it was the other person's negligence that did this, and you could have gotten, I think that in your cross-examination of her, you could have gotten into that a little bit more than you did, because there was some things in the statement of that person that gave you some ammunition to do that. See, Officer Knight's testimony regarding texting, that was not part of the stipulated area of expertise of his. So in order for him to give any type of opinion regarding whether or not the same person texts the one versus the other, there should have been a foundation laid, and if you had objected, I would have sustained it. So if you don't object, it's coming in. And when it comes in, then it's fair game. So if you want to keep things like that out, you've got to stand up and say, I object. No foundation's been laid for this, for that opinion testimony. So I think that's an important thing to remember. Lindsay, you did a very nice job at handling the admissibility of the exhibits. You did it the right way. Very good job. And also, I would echo what other people said. I was impressed with your closing argument. I would say that you started out pretty nervous, but you got rolling. And when you got rolling, you left the notes by the side, and I noticed you didn't even glance at them. That, to me, suggests that, okay, I'm into this now. Every one of you were into it, and every one of you could have done exactly that because you were prepared. So when you walk in and I like watching lawyers in their opening statements and closing arguments, because that's your opportunity to shine and to perform. And so take advantage of that. Get in there and hit the high points and punch the other side pretty good if you can by the evidence, by pointing it out and arguing what it means. Lindsay, you did a nice job doing that. There are things in the testimony of witnesses, and I would just point out two of them. Riley Gardner, for example. Riley Gardner's testimony said, I text the, what was it, no text while driving or whatever that is, and then I tossed it to Sydney, and immediately we got into the crash. We got into the accident. Well, if you look at the text messages, there's a minute and a half between that one and the last one. That's a long time. So if you are able to nail him down that he did get into the accident immediately after texting that and tossing it to, then you can hit him with, well, how come it was 90 seconds between that text message and the last one here? The same thing goes with what was the Alex Williams. I mean, he said he's not the seatbelt police. So he didn't know if anybody was buckled in, except for him. And then later in the statement, he said that Sydney wasn't buckled in. Well, was he? Was he paying attention to it, or wasn't it? So you can point those things out, and the inconsistencies in the statement, and the fact that he admits that he was intoxicated himself, having had, I think he said he had 3 or 4 beers before he was in there, is your opportunity to attack his credibility and his memory and all that sort of thing. So, you know, you look at what the facts are and develop your line in that respect. And what you want to do, like Ms. Lane said here, is you want to impeach the testimony of that person who's against you by making so that the jury doesn't believe what they say, or at least questions what they say, and at the same time hammer in the things that are positive for your side. And that goes for both sides. And you all did a very nice job. And you, young lady, did very good at pointing out that I made a mistake. And no, that's your job. I'm up here scoring you and writing notes, and I wasn't listening to that it was a MySpace. I didn't catch that part of it. So it just fit with the texting thing. So you got my answer that way, and you said, but wait a minute, this is MySpace. And so you pointed out to me something, and you didn't just accept my ruling on it when I was wrong. And that's something that's good. And if I had been right and you were arguing with me, I would have told you to sit down. But you were right. You were right this time, and that's the way it. Yeah.
No, it's not.
So that's a good thing. And I want you to don't be afraid of the judge. Argue your case. Point out things that are, but like Mr. Stremmers is, once the judge makes a final ruling, then sit down, because you're not going to get anywhere with it. But if you point out that there was something that was misunderstood by the judge in that, I think that's a positive thing, and I think, I think you did the right thing, and I just wanted to point that out to you. You weren't afraid of me, which is unlike a lot of people. I hope that you have learned something from this experience. I wish you well in your final round as you go forward. And if you get on to regionals, I hope some of the things that we pointed out here are some things that you can take with you and do well there too. Congratulations.
Thank you.